Another federal gun law was just struck down, this one by the Fifth Circuit Court of Appeals. That's the one based out of Louisiana that covers Louisiana, Mississippi, and Texas. This is the one that bars, quote, unlawful users of a controlled substance from possessing firearms. So no, you don't have to be impaired, you just have to be an unlawful user of. What happened here? What happens next? Let's get some facts into this. My name's Tom Grieve, former state prosecutor, criminal defense attorney. Guys, let's get into it. So this case involves Title 18 U.S.C. Section 922 sub G sub 3, say that 3 times fast, which bars an individual from possessing a firearm if he is an unlawful user of a controlled substance, like, say, marijuana, which remains illegal in a Schedule 1 under the FDA scheduling guidelines because of federal law. We're talking about Mr. Patrick Daniels. He is one such unlawful user, and he admitted as such to smoking marijuana multiple days per month. But the government presented no evidence that he was actually intoxicated at the time of his traffic stop and arrest, nor did it identify when he had last used marijuana. Still, based on his confession, every officer's best friend, the jury wound up convicting him of violating 922 sub G sub 3. Is the law, either on its face or as applied, a violation of the Constitution? That's the fundamental question here. Now, recall, we're going to go into the Bruen test explanation. This was the U.S. Supreme Court speaking up in June of 2022, which laid out the Bruen test. I'm going to give a little bit longer of an explanation here because it's been a little while since I've done that. First, when you look at whether or not a law is going to be constitutional under the Bruen analysis, we must ask whether the Second Amendment applies by its terms. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. That's from Bruen. Second, we must ask whether a given gun restriction is consistent with the nation's historical tradition of firearm regulation. So again, the keywords being nation's historical tradition of firearm regulation. Now, you, the citizen, do not bear the burden of proof of showing that the law is not supported by historical tradition. Instead, it is the government that bears the burden of proof by demonstrating that the tradition supports the challenged law. Only by showing that the law does not tread on the historical scope of the right can the government therefore justify its regulation. The second step, and this is the one that actually the Fifth Circuit alludes to in this decision, this is the part where we're taking it another layer down, requires both close attention to history and analogical reasoning. Bruen did not forswear. Bruen did not basically say, no, it can never happen, such a thing as legislative innovation. In other words, Bruen left open the door to the fact that, look, things can happen. Let me talk about that. To the contrary, the Constitution can and must apply to circumstances beyond those the founders specifically anticipated. That's from Bruen. What we are looking for is a tradition, which is well-accepted limits on the right to bear arms manifested by a tangible practice of comparable gun regulations. But how do we know whether an older regulatory practice is quote-unquote comparable? Well, Bruen helpfully gave us two conceptual frameworks. If the modern regulation addresses a, quote, general societal problem that has persisted since the 18th century, end quote, then the lack of a distinctly similar historical regulation addressing that problem is relevant evidence that the challenged regulation is inconsistent with the Second Amendment. That's going to be important in this case here. But if a modern law addresses, quote, unprecedented societal concerns or dramatic technological changes, end quote, it calls for a more nuanced approach. We must reason by analogy to determine whether older regulations are relevantly similar to the modern law. Now, the Bruen court acknowledged the difficulty of determining whether two laws are relevantly similar. Bruen clarified that two laws are relevantly similar if they share a common why and how. They must both address a comparable problem, that's the why part, and place a comparable burden on the rights holder, that's the how part. The bottom line is that Bruen instructs us that we are looking for a representative historical analog, not a historical twin. And you're going to hear that phrase come up a lot, not only today but elsewhere, of representative historical analog or a historical analog. Now, throughout American history, laws have regulated the combination of guns and intoxicating substances. But at no point in the 18th or 19th century did the government disarm individuals who used drugs or alcohol at one time from possessing guns at another time. A few states banned carrying a weapon while actively under the influence. In other words, when someone's actually drunk, you cannot possess or hold a gun. But those statutes did not emerge until well after the Civil War. Whereas Section 922 sub G sub 3, that's the controlled substance law we're talking about here. The first federal law of its kind was not enacted until 1968, nearly 2 centuries after the Second Amendment was adopted in 1791. Our history and tradition may support some limits, is what the court found, on an intoxicated person's right to carry a weapon, but it does not justify disarming a sober citizen based exclusively on his past drug usage. Nor do more generalized traditions of disarming dangerous persons support this restriction on nonviolent drug users. So if you only have a couple minutes to watch, there you go. That's it. If you want to take this 10 steps deeper, buckle up. Here's some more facts on the case. So this came out in April 2022, where 2 law enforcement officers pulled Daniels over for driving without a license plate. One of the officers, who just so happened to be an agent with the Drug Enforcement Administration, or the DEA, approached the vehicle and recognized that distinct smell of marijuana. He searched the cabin and found several marijuana cigarette butts in the ashtray, and in addition to the drugs, the officer found 2 loaded firearms. One was a 9mm pistol, and the second was a semi-automatic rifle. No further details on that, at least as part of the Fifth Circuit case. Mr. Daniels was subsequently taken into custody, transported to a local DEA office, and at no point did the DEA administer any kind of drug test or ask Daniels whether he was presently under the influence. Nor did officers note or testify that he appeared to be intoxicated in any way. But after Daniels was Mirandized at the station, he, of course, admitted that he had smoked marijuana since high school and that he was a regular user. When asked, what does regular user mean, basically, he said that, look, basically I smoke, quote, approximately 14 days out of the month, end quote. So almost every other day. You can see those in pages 2 to 3 of the decision, linked in the description box below. Now, based on that confession, Mr. Daniels was, of course, charged with a violation of 18 U.S.C. 922 sub G sub 3, which makes it illegal for any person who is an unlawful user of or addicted to any controlled substance to possess any firearm. An unlawful user is someone who uses illegal drugs regularly and in some temporal proximity to gun possession. So the 2 big legal issues emerge. One, is Daniels or anyone who uses illegal drugs part of the, quote, people in the Second Amendment when the Second Amendment says the rights of the people to keep and bear arms shall not be infringed? Are you part of the people? And number 2, is 18 U.S.C. 922 sub G sub 3 part of the nation's historical tradition of firearm regulations and therefore possibly constitutional? Now let's recall, just for those of you who might be new here, that there are 3 levels of federal courts that we're concerned about here. There are 94 district trial courts. That's where the trials happen. There are 12 circuit courts of appeals. That's where you go from trial court up to the Court of Appeal. And then you, of course, have the one and only U.S. Supreme Court, who is not final because they are infallible, but are infallible because they are final. I can't take credit for that phrase. The district court basically said that Daniels is not part. So this is the trial court now. They said that he is not part of the people and that this law that was passed in 1968 is part of the nation's historical tradition of firearm laws and regulations. The trial court judge engaged with a few historical sources from the founding fathers to the Reconstruction, but it relied primarily and largely on statements from other courts, notably, by the way, all predating the June of 2022 Bruen decision, that this law, 922 sub G sub 3, was supported by the historical practice of disarming those who, quote, exhibit a dangerous lack of self-control, end quote. Now, of course, a jury did wind up finding Daniels guilty, and he was sentenced, by the way, to nearly 4 years in prison, including 3 years of supervised release. So let's break this down. We're going to start with the people. The right to bear arms is held by the people. Check the Second Amendment. The phrase unambiguously refers to all members of the political community, not an unspecified subset. That's what the U.S. Supreme Court said in Heller at page 580. In fact, the Bill of Rights uses the phrase, quote, the people 5 times in total. And in each place, it refers to all members of our political community, not just a special group of upright citizens who lead morally perfect and righteous lives. Consequently, the Supreme Court in Heller concluded that the Second Amendment right is exercised individually and belongs to all Americans. Now, true, Heller described the Second Amendment as applying to, quote, law-abiding responsible citizens, end quote. The government seizes on that language from Heller and insists in this case that the Second Amendment does not extend to Mr. Daniels because he is a criminal. However, the court reasons that the term used by the Supreme Court of, quote, law-abiding, now we're talking about what the Circuit Court did in the Fifth Circuit, it was just basically some sort of shorthand to exclude from the discussion the mentally ill, the felons, people who are historically stripped of their Second Amendment rights. This would mean that everybody else is therefore presumptively included in the Second Amendment's protection. Because Mr. Daniels is not a felon, or at least he wasn't until this, because Mr. Daniels is not a felon, or at least he wasn't until this arrest, and there's no evidence that he was mentally ill, this would seem to make the current standing interpretation of this phrase within the Fifth Circuit Court, thanks to their decision on Rahimi, legal. It is important to note that the Supreme Court has also accepted the case that I just mentioned, and where the U.S. Fifth Circuit Court of Appeals is getting this definition and getting this reasoning from, in their case, USA versus Rahimi. So within about 18 months, we may see some language and some decisions move on this. But for right now, this is where the needle stands in the Fifth Circuit. So bottom line, he's part of the people, and you don't have to be morally perfect in order to be part of the people. Let's take a look at the historical tradition analysis. The Founding Fathers and early Republic did not need to deal with our modern drug trade, but they did deal with a lot of intoxication problems, just as we do today. Because there was little regulation of drugs related to guns or otherwise until the late 19th century, intoxication via alcohol is basically the next closest analog that we, as well as the courts, have to look at to see, well, how might the Founding Fathers have ruled? How might the early Republic era have ruled on these sorts of laws? So perhaps if the government could find some kind of analogous statutes or law prescribing the possession of firearms of someone who had been a convicted drunk or alcoholic and preventing them from possessing those firearms even when they're not impaired, the government would be in business. So here the government basically offered three analogs that fall into three kind of buckets. The first one is statutes disarming intoxicated individuals. So we're talking people who are actively under the influence and impaired. Number two are statutes disarming the mentally ill or insane. And number three, statutes disarming those adjudged to be dangerous or disloyal. Now, as you can see, and unfortunately for the Department of Justice lawyers who argue their case, that regulatory tradition is sparse and limited, so saith the Fifth Circuit, during the relevant time periods in question. Again, generally we're talking early Republic, so pre-1830, and generally these things really start to fall off as you get to the U.S. Civil War, 1860s. Now, despite the noted prevalence of alcohol as well as alcohol abuse, neither the government nor any of the briefs that came in to support the government could identify any restrictions at the founding that approximate something like we have in 922 sub G sub 3. Although a few states after the Civil War prohibited carrying weapons while under the influence, none barred gun possession by regular drinkers. Now, if you want to see more detailed breakdown of all those types of laws, please let me know in the comment field below. This video is already going to be getting a little too long for my taste, so I'm just going to cut that off here. Suffice to say, the Fifth Circuit said that it was not enough after engaging in a very lengthy and quite exhaustive historical analysis. They also turned down the government's arguments that laws against quote-unquote lunatics and people who are mentally ill from possessing firearms are likewise analogous to sober adults who occasionally use drugs. Lastly, the court also rejected the dangerous and disloyal part, and their reasoning is quite long and it goes into areas and times of political turmoil and upheaval and so forth. So once more, if you want to see this go way more in depth, please let me know in the comment field below, and I'd be happy to basically get that on my project board and get something rolling. I've got 4 bottom line takeaways, as well as, of course, the quote of the day for you. But first, if you've not already done so, please help me as well as this channel out. Tell the YouTube algorithm that this needs to get out there. Click that like button, absolutely free. Don't miss any of our future content. Be sure to hit the subscribe. And if you want to support our project, please consider clicking the join button, becoming a member. Tremendously appreciate it. Some extra giveaways there as well. But we appreciate you all just being here, whether you are a regular viewer or you're just kind of browsing through and stop by. Thank you. Here's our 4 takeaways. Number 1, the Fifth Circuit continues to crush gun control laws and to be, frankly, the best circuit for the Second Amendment in the entire country. I've talked to a couple attorneys who actually filed these kind of cases just in the last couple weeks, and they both agreed that while there's another circuit that could be more conservative, the Fifth Circuit has definitely not been afraid to move the ball upfield when it comes to the Second Amendment, as well as some other big issues. Number two, this case will invariably be appealed, and right now it's only precedent within the Fifth Circuit. So let me be emphatically clear. I am 0% suggesting that is now legally safe and you'll never be charged, arrested, or anything like that if you go out and possess firearms in violation of 922 sub G sub 3. Sorry, that's just the only sane thing I can say. And as a reminder, none of this is legal advice anyways. Number three, this case is linked to another that we've talked about before in this channel many times, which is U.S.A. versus Rahimi, which we've likewise referenced in this video. That's the one that prohibits folks with the domestic violence injunction from possessing firearms that has now been accepted by the U.S. Supreme Court. And they both deal with the question of who are, quote, the people. And again, as I already noted, SCOTUS, the U.S. Supreme Court, has already accepted this similar issue. However, what this case raised separately from that is that it does raise and address emergent questions concerning the interplay and nexus of the scope of tradition, as well as the permissible breadth of historical and legal analogs. So those are some new issues that are being raised here, even though some of the issues are raised and are going to be settled one way or the other by the U.S. Supreme Court in Rahimi in the upcoming term. Number four, I would not be surprised as a result of what I just said if this case also goes to the U.S. Supreme Court. Though again, that first issue is going to be getting resolved by Rahimi, but I would be shocked if the DOJ does not appeal this upwards. So there you go. There's your 4 takeaways. And now here's your quote of the day. This one comes from Fyodor Dostoevsky, the one and only. Quote, "The second half of a man's life is made up of nothing but the habits he has acquired during the first half." Thanks very much, and I will see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.